At the beginning, when we talked about an introduction to law, when we talked about what you are going to do in your first year of law, we said that we're basically going to look at different types of law. We made a distinction between private law and public law, and then private criminal and public, and we also made another type of distinction between national and regional and international. And if you look at what I'm going to try to do in the last 15 minutes, is to do a repeat of what I did in the last workshop and make an overall summary of what this course has been about. So if the exam question would be, what is EU private international law? Then probably what Mr. Van Bemmelen and I would say what Mr. Van Bemmelen and I would probably say is that in this 7-lecture series of 7 lectures and 7 workshops, what we have attempted to explain to you is what EU private international law is. In first instance, we have indicated that this topic relates to private law. And Mr. Van Bemmelen in his first lectures has given you a little bit of an outline, if I'm not mistaken, and he dealt with notions of contract and tort, just to make sure that before we go into the difficult combination of EU private and international law, that the first step was this is linked into the field of private law. In addition, we talked about second step, second building block is to say private international law. So we said private law first step, private international law second step. And then in Mr. Van Bemmelen's first and second lecture, he has explained to you what this concept of law is about. It's not something that we did in intro to law like comparative constitutional law. It's not the study of a certain field of law. Private international law is an actual body of rules of law. That's the late component of law. Private international is an actual body of law. And in his second lecture, he has indicated that that section of body of law deals basically with 3 legal issues. Right? It's a set of rules or a body of rules that deals with 3 key issues. The 3 key issues are what court is going to be competent, what rules are going to apply, and what do we do with recognition and enforcement of judgments. Right? So the first lecture was putting this into context of private. Second lecture was saying private international is a body of law that deals with these 3 issues, and in addition, it's something, private international is something that features not only at an international level, not only at a regional level, but also at a national level. So it's a body of law, private international is a body of law that deals with 3 questions, and that is part or can be found in both national law, regional law, and international law. And what Mr. Van Bemmelen has done in the beginning is he's given you a historic and analytical overview of how, especially in national law, different approaches in relation to this body of law have developed. If you have to draft rules, so he basically provided you with an overview of if you would be a new country and you would have to start writing within this body of law your own national rules, what are the different approaches that have been taken in the past in order to draft these rules? Right? And he's indicated for you find it in national law, in regional law. He's given you 4 or 5 slides of examples of where all these rules can be made, and also at an international level. In relation to the international level, amongst others, he's indicated the Hague Conference as an engine for creation of international instruments. When I have come in lecture 3, what I have done is to say, now that you know that this is part of private law, that it's a body of law that deals with 3 questions, let me help you to understand how this private international has come onto the specific agenda of the EU. EU law is part of regional. There are different interregional organizations, and you'll find instruments in relation to private international law in different settings. What I have tried to do in my first lecture is to say this is how private international law has come into the portfolio, the competence portfolio of the EU, and how it has come that the EU now can make its own, or can fill their own box, is to say there is something as EU private international law, and the EU is competent to make laws in that section of law. Right? In that lecture, I have identified, or we went over a process where we said 4 main phases to be subdivided in 2 big blocks. Historically, at the beginning, everybody knew that private international law is out there, that it's a useful set of laws to have, but that it's not part of the competence of the EU. Therefore, there was a suggestion from member states, please, it's important, go out and make conventions or international agreements to make sure that we have rules that are going to support the economic integration within Europe. Rome, Maastricht, Amsterdam, Lisbon. Afterwards, as in Amsterdam, it becomes part of the portfolio of the EU, Articles 61, 65, and then later Article 1. To say this now is part of the competence of the EU, and we can start to draft legislation in the field of EU private international law. In my second and third lecture, and then in Mr. Van Bemmelen's fourth and fifth lecture, or third and fourth lecture, what we have done is to then say, let's zoom in on. You now have your, it's part of private international, it deals with 3 questions, it occurs at different level. If we zoom in on the European Union, then let's look at how these 3 original questions, jurisdiction, enforcement and recognition, and applicable law, are being dealt with at an EU level. In my 3 lectures, I've dealt with what instrument? Brussels I regulation. Right? And we've gone into detail into the Brussels I regulation, because that instrument gives an answer to which 2 questions? Good. So both in relation to jurisdiction and in relation to recognition and enforcement. An important section, or a bridge between the historic introduction and the Brussels I regulation, is that I've indicated how the 2 are linked. The idea that the ideas in the Brussels I regulation are not drafted from scratch, but build on the Brussels I convention. And inside of the Brussels I regulation, we then looked at how does this work. We've looked at the material scope of the Brussels I regulation, to say it should have some kind of an international dimension, it should not be excluded by, remember the other point? 1 paragraph 2. And what else? We had 3 criteria to say civil and commercial. Right? And then we moved on to say if within EU private international law, if we have developed, if we've written law that deals with the question on jurisdiction, then we basically have come up with 5 methods that will allow us to identify what court would become. And those 5 methods were exclusion, prorogation, weak party, special jurisdiction, and main. Okay. We've identified those in that order just to simplify the application. If you would look at the basic philosophy of the Brussels I regulation, then what is the main idea behind the Brussels I regulation? If you would have to pick one of the 5, if you could only have one, what would be the basic idea? Would be the main movement. Article 2, that cannot be applied. You have to use, as Mr. Van Bemmelen said, I'm not going to go into the agricultural comparisons of milking and farming. the idea is Article 2 in itself, you've come to the end of your year 1, you know that you can't use an article in just loose from all the other articles that are around it in the same instrument. So with Article 2 we saw, if you're going to apply that, relation to Article 2, it's looking for the definition of domicile, right? Back into Articles 59 and 60. 59 for natural persons, 60 for legal persons, right? The idea was, basic philosophy is Article 2. Combined reading with 59 and 60 so that they have a clear idea. In my next lecture, what I added to that is that you've seen the 5 mechanisms, but this idea that certain of these mechanisms are more important than others create for an additional set of rules that help judges. One of the rules that we saw was if a judge gets a case and he needs to assess whether he has jurisdiction, that he should, under all circumstances, we use the term jargon, we use ex officio. It is his professional responsibility to check. To check what? What must he check? The exclusive jurisdictions, right? To make absolutely sure that we're dealing, if exclusive jurisdictions are at hand, that is checked. We also talked about the Owusu case that said, and if we're dealing with these different methods of allocation, if you would come to apply the main rule, these judges should get it into their, bleep that, else you'll probably find another word, the expression that was given, they should get it into their big skull that national law does not exist in abstracto of European law. And if we agreed something on a European level, that there is going to be such a thing as the main rule, that they can no longer use their national rules to deviate from the application of the main rule. If we've agreed at a European level, then that rule should get applied. Right? Made reference to one of the cases. And what in addition I have indicated, flanking things that can happen is to say, what we've discussed about the Brussels I regulation is basically a rule that helps you to identify what courts could be competent to deal with. It is never going to identify, in most cases, it is going to identify the rule, the application of the rule is going to identify more than just one court. And there are a couple of additional rules there that help you do, if you have to do this in practice, that bring this into a realistic perspective. One rule that we identified was least penalties. If there are multiple courts that are on your list, then it's going to be sort of first come, first served basis. The court that can claim jurisdiction first is going to be able to deal with the case, and the other courts should basically take a hands-on approach. Given that one court has been able to successfully claim jurisdictions, the others should refrain from dealing with the case. An additional rule when it comes to applying this in practice is, we said, Brussels I regulation identifies courts that may have jurisdiction. But if one of the courts, if you would be sued before a court that isn't on the list, and you go in there and you argue the case itself, then European legislators have tried to provide you with some kind of legal certainty of where it is that your case could be brought before court. But if you say, I don't particularly care about the idea of creating legal certainty for me and just having a limited list where I can be sued, if you agree to go into any other court, that will basically overrule the allocation mechanisms of the Brussels I regulation. If you consent to another jurisdiction, then you're entitled to, and a judge should not feel restrained by the fact that there are these rules under the Brussels I regulations. If both parties appear before him and they're willing to settle the case in his or her court, then that judge can continue and proceed.
Doesn't that go against the Owusu case? Doesn't that go against the Owusu case if they say we agree?
How would you say that goes against the Owusu case?
Or because they say you can't deviate from agreements that are made at the European level. So you can deviate from the Brussels I, but then if the party says, I don't consent to this jurisdiction.
The idea, the question is, does that, if you look at the dynamic behind the Owusu, is that not a contradiction? What Owusu said is the idea, if a judge would seek to rely on his national rules is not an option for him. What the example that I've just given does is to say, also in the Brussels 1 regulation, it says that a judge, so he's not relying on his national rules, but the Brussels 1 regulation says if somebody is willing to, or sometimes as stupid to appear in your court without giving full consideration of the consequences of engaging in your courtroom, that we give you the authority to say we should not question the issues of jurisdiction anymore. If both parties are here and they're willing to engage in this case here, then that is what we're going to do. So it is not contradicting Owusu, because the rule that the judge would use is in the Brussels 1 regulation itself. And then the last thing I talked about is recognition and enforcement.
Before recognition.
Yeah.
For the least Spanish school, is it the first court that declares it as jurisdiction, or the first seized court? Because the courts may be seized at the same time, and the one of them will have jurisdiction, and the other one, and the also gets to have jurisdiction.
For the purpose of a year 1 introduction to, it's the court that has ceased jurisdiction.
Okay.
Because you could send out letters at the same time. And for one letter, it could be that the procedure take 4 or 5 weeks before the judge expresses himself, and in another situation, it does not. Okay? Other questions on what I've explained so far? So, forum domicile. What was the definition of forum domicile? Have you heard the question? So the question was, what is the definition of forum domicile? If that would be an essay question, sort of putting Mr. van Bemmelen's suggestions in practice, how would that work? What is forum domicile, or what is the definition of forum domicile? How would you approach it?
Forum domicile
Forum domicile is what?
is the place where the person is domiciled.
So forum domicile. Forum always indicates, if you're talking about lex something, then you're talking about applicable law. If you say forum, then we're looking at what court are you going to bring your case in. So forum domicile refers to the court of the place where somebody is domiciled. Or if you have to look, if you'd say, where do I find the notion of forum domicile, then that equals the main rule. Because that is the idea behind the main rule. You can try a person in the place where he or she is domiciled. Is that a sufficient answer to your question? Good. Other questions? Yes?
Yeah, I just want to know the name of the case which says that national, like the judges don't need to apply the national law but EU.
If you have your reader with you, it's page 59, Owusu versus Villa Holidays, Ball in Villas. Just page 59 in your reader. Yes.
Where in the process of regulation does it say the additional rule that if the two parties are willing to go to this specific court?
Can I push that question back to you? I see that there's a copy here. If you take a minute to look that up, and if you don't find it, then get back to me. Right? Other question?
After the main rule, we have to check whether jurisdiction is applicable or.
In the way we have said that we apply these 5 mechanisms is to say exclusive overrules all the others. So you could start, like Mr. Van Bemmelen indicated, if you would be a junior judge and you would say, let's apply the Brussels 1 regulation, you would start with Article 1, scope of application, Article 2, the main rule. But then, if you would do the entire application of the main rule, you may, at a certain point in time, come to the conclusion that the exclusive jurisdictions apply. So when we talked about the flowchart, we said it's more useful, if you look at the application of the law, to first deal with the one that would override all the others. So first deal with exclusive, then deal with prorogation or weak party regimes. If none of those apply, then you're going to seek whether the main rule and special jurisdictions and the main rule are applicable in your case. Is that an answer to your question? Okay. So,
One
one question. The criteria that you're saying of Article 1 and also related to Article 1, Paragraph 2 and interventional character, should we also take into account the criteria of ratione loci, ratione temporis when we are writing? Can we do it or not? Or it's fine?
You can absolutely do that. Just make. I don't see why you could not. There is a date of an entry into force of the regulation. So technically, if you look at the scope of application of the Brussels 1 regulation, there is not only a material element, but there is also a time element. So technically, you cannot apply the rule before it has entered into force. If you would add that to your analysis of, then that can only make it a little bit more perfect. But that is not a standard requirement because we haven't emphasized that during this lecture. Have you found your rule already?
No.
You have not. Okay. Other questions? Yes.
Only other day I think the question was to learn more about the recognition. And just, for example, straight example. Just an example.
I'll try to pick your question up once I've given another explanation about it. The article you're referring to is Article 24. It says, apart from jurisdictions derived from other provisions of this regulation, a court of a member state before which a defendant enters an appearance shall have jurisdiction. Right? So if a defendant appears, enters an appearance, that court will have jurisdiction. Okay? Yes, sir.
I have a question with regards to national reports, but not from Brussels, but from Rome 1. Should we take into account the 17th of December, or we should also write the 17th of June with regards to the contract?
Mr. Bemmelen, the floor is yours.
Depending on the question. So the question is a good question in terms of legal thinking that you always ask yourself with any R, including a full regulation, the conflicts, ratione tempore, that you always ask yourself, time-wise, is it applicable or not? Is the R alive or is it dead? And then technically, that is sort of puzzle in the calendar, with entering into force dates and other non-interesting things. So the key thing here is that you put for the rest of your career on your radar, rules do not have eternal life, so they emerge and they go away. And the one I am using is that live and kicking. That's the ratione tempore you need to know.
And if you go back, maybe that's not the exam, but just for you to know if you go forward, what I have told you, the Brussels 1 regulation has an expiration date 10th of January 2015. There's already another regulation that has been adopted and that has been set to be put in motion as the 10th of January 2015. There are going to be some difference, but if you would have to apply the rule now, then it's a Brussels 1 regulation. If after the 10th of January 2015 you seek to apply, you're going to have to look at a different legal instrument, and you're going to be able to compare what has changed, and then there may be an idea about why these things need to be changed. And that's what I talked to you in my first lecture, is that EU law is always going to continue to evolve, and that's your responsibility if you go forward to keep on looking at as how this body of law keeps on changing.
In relation to Article 24, what does appearance mean? Like sending or literally appear?
It could mean, it's a good question because it asks for a definition of the term used in a legal document, right? And it could mean a variety of things, ranging from submitting documents as part of a legal proceeding, having somebody represent you, to the full spectrum of being there assisted